Thank you and good morning. My submissions this morning on behalf of the Human Resources Professionals Association of Ontario, or HRPAO, will be focused on the use of doctor's notes in order to identify disability-related absences for the purpose of accommodation. We start from the basic proposition that when someone with a disability is away from work, that absence can be put into one of two broad categories. It's either disability-related or it's not disability-related. If it's disability-related, it's entitled to be accommodated at least to the point of undue hardship. Of course, if it's not related to disability, there's no need to accommodate. Employers need to be able to distinguish between the two types of absences. And the reality, of course, is that most human resources professionals or other people tasked with attendance management or disability management are not medical professionals. They rely upon information from medical professionals, and that is why doctor's notes are such a commonly used tool for the purpose of attendance management and for disability management. The HRPAO sought to intervene in this matter out of a concern that the wording of the lower court decisions could be interpreted as suggesting that when someone has a known disability, the employer cannot require that they bring doctor's notes to identify which absences are disability related. Now, regardless of how this court may rule with respect to the specific factual circumstances as between Honda Canada and Mr. Keays, and we take no position with respect to those specific facts, we do ask this court to confirm that requiring an employee with a disability to bring a doctor's note identifying which absences are disability related is not prima facie discriminatory. And to be clear, we're not seeking a pronouncement that employers should always be entitled to require such notes. We're simply asking this court to confirm that there is no absolute prohibition against doing so. Our submissions will be that, like many other applications of the doctrine or the duty to accommodate, each case has to be assessed based upon its own specific facts in order to determine what's reasonable. Practically speaking, until an employer knows that a particular absence is related or caused by a disability, they can't be said to have a duty to accommodate that specific absence. The duty to accommodate is triggered, taking a step back, the duty to accommodate is triggered when someone has a disability, and that disability limits the individual's ability to carry out their duties. It's not the disability that is accommodated so much as it is the limitations that the disability creates. From an employer's perspective, they need to know when and how accommodation is required. And in many, perhaps most cases, the limitations and the corresponding accommodation will be constant. Take, for example, someone who has a hearing impairment. They may require special telephone equipment to carry out their job, and that will stay the same from day to day. Contrast that with someone who has a condition like the respondent in this case, who doesn't need accommodation every day. They need accommodation for sporadic, unpredictable absences. And the individual will not know, and the employer certainly cannot know, how often they will be absent or when. And if you take any given day, if the individual is away from work, the employer doesn't know whether that absence is related to the disability or otherwise until they have some sort of medical documentation to say that it's disability related and therefore entitled to accommodation.
Part of the problem in this case, I think, was the requirement of a constant series of notes every single time it happened. Given the nature of something like chronic fatigue, and assuming that the employee in this case had it, you've got a series of notes where the doctor says he states that. How reasonable a requirement is it that in every single instance of an absence, given a diagnosis of chronic fatigue syndrome, it's helpful to have this doctor's note which simply reiterates what the employee says in any event? Isn't it unduly burdensome in the circumstances and not assistive necessarily of the employer's concerns that you've outlined?
Your question provides a good example of exactly why we are not asking for a rule that says the employer is always entitled to require doctor's notes. There may well be circumstances where it's just not reasonable or not appropriate, and again, that's why we're not asking for an absolute rule. However, we would submit that situations where a doctor can do no more than simply transcribe what the patient tells them will be extremely rare, and that we would certainly be wary of setting a precedent that is based upon the notion that the doctor can do no more than that. In most cases, there will be value to having this individual see a doctor quite apart from doctor's notes, but just to have ongoing treatment. So our submission is that in most cases there will be a value to seeing the doctor and is not unduly burdensome to require them to do so and bring a note. But again, like the duty to accommodate generally, we all know the duty to accommodate is to the point of undue hardship, but no one has set out in black and white what the point of undue hardship is, because that has to be assessed based upon the specific circumstances of each case. And our submission is the same type of analysis should be done with respect to the requirement for doctor's notes. And Justice Abella, getting back to a question asked earlier about whether this requirement will unnecessarily prolong absences, we would agree with previous submissions. We're not suggesting that the note is essentially an admission pass to get you back into work the next day. We're not saying the note has to be provided that day or the next day, as long as it's provided in a reasonable time. All that an employer needs is to know that that absence was disability related, and then they will accommodate it. Now let me explain our concern with respect to the lower court's decision. I've included an excerpt from the trial judge's decision in my condensed book, to summarize it, when Mr. Justice McIsaac refers to the requirement of bringing notes, he is quite critical of Honda requiring that Mr. Keays bring a note for every absence, and he finds that requirement to be discriminatory. Our concern is that the finding is not explicitly based upon the specific facts as between Mr. Honda and Mr. Keays, which again we take no position on, and it could be interpreted as saying, as a broader statement, that when someone has a known disability, you can't ask them to bring a doctor's note in identifying which absences are disability related. I mean, the wording of Mr. Justice McIsaac's decision almost suggests that the duty to accommodate a particular absence arises before the employer even knows that the absence is disability related. It practically speaking assumes that every time someone with a disability is away from work, that absence is disability related. Our submission is that that's certainly not an appropriate assumption and could lead to quite illogical and impractical situations where an employee with a disability cannot be required to bring a doctor's note showing when their absences are entitled to accommodation. They would effectively be exempted from attendance requirements, from attendance management programs, even when their absences are completely unrelated to their disability. And in our submission, that would be unfair to the organization, unfair to other employees, and could have significant impacts upon organizations' morale of employees, productivity, and competitiveness more generally. And more importantly, perhaps, such an approach would be inconsistent with the existing law. This court confirmed last year in McGill University Health Center that there is no doubt that an employer may establish bona fide measures to ensure employees' regular attendance. We also know that with respect to accommodation, employees have a duty to be a part of the accommodation process and to provide appropriate medical information, setting out what their limitations are and what accommodation is required. There has been the suggestion that the form of accommodation, in this case, requiring a doctor's note to identify which absences are disability related, was somehow a discriminatory form of accommodation. Our submission is that it's not discriminatory, it's simply a practical and perhaps the most practical method of determining when accommodation is required. When assessing a particular form of accommodation, we would also remind this court of its own decision in Central Okanagan and Renault, where it was clearly stated that employees have an obligation to accept reasonable accommodation. They're not entitled to a perfect solution. And the last case that I would turn this court's attention to, and this is included in my book of authorities and excerpts are in the condensed book, it's the Dashwood Industries case, which is an arbitral decision. And in my submission, it's a good example of how this analysis should take place. Briefly stated, in that case, the aggrievor had a disability, there's no question about that. He sought to have his disability-related absences accommodated. The employer agreed to accommodate any absence that was related to their disability, but asked for doctor's notes identifying specifically which absences were disability-related. The union objected, saying that it was essentially unfair and unreasonable to ask this gentleman to go see his doctor or go to a clinic every time he was absent. And arbitrator Newman reviewed the facts and also reviewed the law with respect to the duty to accommodate, which I have touched upon, and found that in that specific case, there was no evidence to suggest it was unduly harsh to require this gentleman to go to a doctor each time, and that it was not discriminatory to make that requirement. So our submission is that this is the appropriate analysis. There shouldn't be an over-inclusive rule either always allowing or always precluding the requirement of a doctor's note. It should be assessed based upon the specific facts of each case, just like the duty to accommodate to the point of undue hardship is assessed based upon the specific facts of each case. Thank you.
Thank you. The court will rise for its morning recess.